Godson, Director of Policy Exchange, and delighted to be able to welcome you this afternoon to a keynote lecture by Right Honourable Robert Buckland MP, Lord Chancellor, particularly apposite timing because he's just introduced today the second reading of the Judicial Review and Courts Bill, a subject of great interest to Policy Exchange for a number of years through our path-breaking Judicial Power Project, chaired by Professor Richard Eakins of Oxford University, recently appointed chair in constitutional law there, and who has been working with us for a number of years on this topic. Started with one of your predecessors in 2015 with who gave the introduction to a very fine lecture by Professor John Finnis of Oxford University, then a collection of essays surrounded its publication, and we were particularly pleased to welcome a forward by Lord Chief Justice Sir Ian Burnett, which was intellectually a very important contribution, and it set the stage, really, all that collection of essays for a broader examination of the proper role of judicial power, of the proper role of judicial review, and of restoring a balance to the traditional constitution. And it's a particular pleasure to welcome this Lord Chancellor today, who's played so singular a part himself in the debate. He's going to speak for half an hour. We're then going to throw it open. Questions, floor, usual Policy Exchange House rules. No question too outrageous. You simply have to state your name and organisation first. So if you'll be so kind as to put up your electronic hand, and I know that there are many here from many walks of life, not least from the legal profession, not least from the bench itself, whom we are delighted to welcome today on this conversation, old line of Stalin in the matter of arms production. Eventually, enough quantity becomes quality, but we've had both quality and quantity here today. And without further ado, Lord Chancellor, we look forward to hearing what you have to say. Thank you for coming today.
Well, thank you very much indeed, Dean, and thank you to Policy Exchange for inviting me to speak here today. I'm very grateful for the work that Policy Exchange's Judicial Power Project, as Dean referred to, has done over the past 6 years. And that work seems to me to be crucial in two vital respects. First of all, scholarly commentary has an important role in developing and refining the law. And I'm sure that all students of criminal law will recall how the House of Lords, in the case of Anderton and Ryan, how shall I put this diplomatically, misconstrued Section 1 of the Criminal Attempts Act. And very soon after that decision, Professor Glanville Williams wrote how shall I describe it, scathing commentary of the ruling. And a year later, in the case of the Queen and Shivpuri, their lordships corrected course. Now, when it comes to public law, there can be a tendency in sections of academia to want the courts to expand on their power. And I think the Judicial Power Project and the academics associated with it provide an important counterweight to this tendency. Now, the second reason why I think your work is so important is that the debate about the proper balance of the Constitution is too crucial to be left to the pages of the Law Quarterly Review or of public law. It concerns us all, whether we are lawyers or not. And your work has really brought these issues into wider view. So I want to start by saying something about my underlying thinking when it comes to constitutional reform itself. I think it's fair to say that I am guided by three principles. And the very first is a principle of method. And I think it was Michael Oakeshott who put it best, and I quote, "To be a conservative, then, is to prefer the familiar to the unknown, to prefer the tried to the untried, fact to mystery, the actual to the possible, the limited to the unbounded, the near to the distant, the sufficient to the superabundant, the convenient to the perfect, present laughter to utopian bliss." Now that means, in my book, that one should never seek to, more prosaically, reinvent the wheel, and that change, where necessary, should be incremental. Now the second part of my principles is the rule of law itself. What I mean is that as a society, We are governed by clear rules set in advance and not by the arbitrary choices of those in power. Now, that's a fundamental principle of our Constitution, and I wouldn't want any reform to endanger that. And the third is the sovereignty of Parliament. In order for life in common to be possible, the laws that govern us must be oriented towards the common good. But what the common good means is, of course, open to interpretation. As Winston Churchill said, the least bad way of settling those disagreements is through democracy. But it is our Constitution that gives the final say to the elected Parliament, not to the unelected branches of the state. I think that's a very sensible settlement, which has served us all very well. Now, in my lecture today, I'd like to take the opportunity to build on two speeches I made recently concerning our Constitution, one at Queen Mary University of London and the other at University College London, and specifically to discuss the government's thinking behind our proposals for reform of judicial review. As I said in both those speeches, our system and our Constitution have evolved over centuries to serve the needs of the citizens in our country. It's inevitably the case that through all that change, the Constitution will at times require some attention, some constitutional plumbing, if you will, to ensure that it continues to strike the right and sensible balance between our institutions. This afternoon, the government has introduced the Judicial Review and Courts Bill, the judicial review elements of which I hope do exactly that. Now, it's clear to me that the executive and the judiciary, as branches of the state, are servants of Parliament, which derives its power and authority through the democratic process from the people of our country. We each have a responsibility to respect what Parliament tells us and how it wants us to interact in the interest of just outcomes from the laws it creates and the powers that it grants to us. Now, the judicial review elements of the bill grew out of the Independent Review of Administrative Law. And in their report, the IRAL panel charted developments in judicial review over the last 50 years or so. And the panel wrote at length about the diminishing field of non-justiciable areas, highlighted the court's inconsistent approach regarding nullity, and reflected on concerns expressed by others around ideas such as the principle of legality. Now, the panel also pointed out several instances where the courts have not had remedies at their disposal that provide the flexibility that they need, and that this prevents the courts from dealing with judicial review cases effectively. Now, the panel concluded that, in the main, judicial review is not in need of systemic reform, and the answer to any judicial overreach is judicial restraint. And that's something which does not require legislation. Now, these are views with which I strongly agree. For me, this has been a process of reviewing the changes to judicial review over the past 40 years, both in individual cases and in the context of our constitutional balance, and asking this very sensible question: is judicial review in our country functioning as it should? I'll focus today on one half of the proposed reforms, removing carte judicial reviews. And you'll see from the Judicial Review and Courts Bill that the ouster clause we are proposing primarily removes carte reviews due to the resources that they use. And I think Lord Brown's words in the carte judgment are relevant, and I quote, "The rule of law is weakened, not strengthened, if a disproportionate part of the court's resources is devoted to finding a very occasional grain of wheat on a threshing floor full of chaff." But it also does something else. I hope it can provide a model for how such clauses should be used, and draw a line under the legacy of Anisminic, that famous case, almost as old as me, which led to ouster clauses being rendered almost wholly ineffective. Now, I note that the debate happening around judicial review at the moment is a robust one. In a mature, a healthy democracy like ours, that is exactly as it should be. But unfortunately, those, including the JPP, who have expressed concerns about certain developments on judicial review, have had one or two positions attributed to them. Now, the first is that they want to abolish, or at very least severely weaken, judicial review in order to unleash executive power. And the second is that critiques of developments have at best only identified a few cases where the courts have got it wrong. And so the argument goes, any system of law is bound to get some cases wrong. So essentially, there's nothing to see here. Now, to my mind, both of those claims are wrong. But I do think we should be clear about the aims of the government in this exercise. Now, judicial review is a crucial tool to ensure that the executive sticks within the bounds of the powers it has been granted. It's essential to the rule of law, and we would not want to get rid of that. No one is suggesting that we turn back the clock on judicial review, and certainly there is no desire, not from me, not from the wider government, and not from the vast majority of constitutional scholars and experts, to undermine the useful innovations and developments in judicial review in the past 40 years, of which there have been many. But while some are clearly useful, for example, that there are always limits to discretion and undoubtedly enhance judicial review, there are other developments which could take judicial review in more worrying directions, and so I think we must be cautious. But it is not the case that these concerns are merely about the belief that a few hard cases should have been decided differently. In my UCL speech, I focused on two cases, Evans and the Attorney General, and Privacy International versus the Investigatory Powers Tribunal. In response to that, one commentator said that there was nothing more to it than a disagreement with the majority in two high-profile Supreme Court cases. The argument seems to be there are borderline cases and there will be disagreement about how these should be decided. That's unexceptional. However, with respect, that misunderstands my point, which is that a case like Evans should not have been borderline in the first place. As Lord Hoffman put it, and I quote, "It is hard to see how Parliament could have made clearer its intention." The fact that this clear intention was not given effect to, and I quote, "gives rise to a worrying impression of a tendency towards judicial supremacism." And those latter words aren't mine. They're the words of the noble Lord Brown of Eton under Hayward, formerly of the House of Lords and, of course, of the Supreme Court. When we look at the evolution of judicial review over the past decades, we also have to ask ourselves whether developments serve its actual purpose. It can be seen to operate in many ways through an interpretation of what Parliament generally intends, as it would be impossible for legislation to cover every conceivable circumstance in which it might be applied. That is what should guide us in any analysis and proposals for change. Because Parliament doesn't specify in exact detail all the necessary requirements and ways a power it grants should be used, the courts must fall back on certain assumptions about how Parliament generally expects decision makers to act. And due to the necessary breadth of these assumptions, for instance, that a decision maker should not act unreasonably, it's easy to see how they can become victim to conceptual creep and overcomplication. Now, in general, I firmly believe that the courts take a practically minded approach to judicial review, and in the majority of cases, there's no cause for concern. But we shouldn't be lulled by this into a false sense of security, and we must be watchful for those cases which might demonstrate a change in conceptual growth or indeed overgrowth. Now, I think there are broadly three areas where, to a greater or a lesser extent, there's a risk. In all these areas, we must ask, firstly, what is the justification for assuming that Parliament generally intends its legislation to be interpreted or read in this way? Now, the first is the possibility of the misuse of Wednesbury due to the potential difficulty in finding an objective way of measuring it and the varying levels of intensity it is said to have. On the latter point, Lord Justice Haddon Cave's recent Gresham lecture is most helpful, and I quote, "The constant refinement and enigma variations on Wednesbury and the spawning of a myriad of different public law tests in an attempt to achieve perfection in every scenario has led to a great deal of obscurity and entanglement. Bright lines are no bad thing in the good administration of justice and good government. Not everything can be nuanced. In the slightly Alice in Wonderland world of close or anxious or intense or quite intense scrutiny in public law, you will forgive me for asking, is today Wednesbury or Thursbury and Fribury? Close quotes. Second are the calls for proportionality. The idea that the court does not just look at whether the decision maker has properly used the powers given to it by Parliament, but also whether the decision or action is a proportionate way of achieving a policy aim to become a general ground of judicial review. Now, this would fundamentally change the role of the courts and risk a kind of adjudication which draws the judiciary into political questions or ones that are based around values. Indeed, the courts have pointed out such dangers themselves. For example, Lord Neuberger in Kew in the Foreign and Commonwealth Office summed up the risk in this way, and I quote, "The move from rationality to proportionality, as urged by the appellants, would appear to have potentially profound and far-reaching consequences, because it would involve the court considering the merits of the decision at issue. In particular, it would require the courts to consider the balance which the decision maker has struck between competing interests, often a public interest against a private interest, and the weight to be accorded to each such interest." Close quotes. In the absence of explicit parliamentary authorisation, as was provided in the Human Rights Act, proportionality should not be seen or to become a standard ground of review. Now, the third concern is around the principle of legality. The IRAL report discussed one element of this, the lack of certainty about the triggers for the principle of legality. And another is the concern that Professor Varajas has raised about what he terms the augmented and the proactive variants of this principle, which, and I quote him, makes significant roads into executive discretion and Parliament's capacity to reshape the common law, even where it manifests its intent by clear words. Now, whilst we can view these developments as the court striving to balance the very practical matters inherent in judicial review with complex legal principles, we must also be alive to the risk that the principles can start to take on a life of their own and lead to the court's overreaching. The IRAL, in their report, concluded that, and I quote, "Solutions to any potential problems of judicial overreach and uncertainty created by the current state of the law on the grounds of judicial review must come from the courts, and the courts should be encouraged to do what they can to address these problems." Close quotes. I agree, and I'm encouraged by recent decisions of the Supreme Court. Now, one of the concepts over which there has been much judicial and academic comment is the requirements for the effectiveness of ouster clauses. And I think this is a perfect example of where something has become more and more complicated, resulting in problems far beyond the real nature of the issue. A problem which arose out of the Anisminic judgment and which we are determined to resolve. Now, Anisminic, as Lord Wilson put it in his dissenting view in Privacy International, and I quote, "set up 50 years of linguistic confusion for all of us who have been heirs to its decision." Close quote. This confusion was over the nature of different kinds of errors and whether all errors were in fact so-called jurisdictional errors, that is, one where a decision maker acts without the power to do so, and have always been considered as making the action null and void. Professor Feldman's commentary on the context of Anisminic highlights several points that can, I think, help us to understand how this confusion arose and why it is less the case itself rather than its legacy which has led to the confusion. Now, the case revolved around a decision of the Foreign Compensation Commission, which had been set up following the Suez crisis and the seizure of assets by the Egyptian government. The Commission's role was to determine compensation claims by affected British citizens and companies whose property had been seized. Anisminic, or in its other name, Sinai Mining, was one such company. But the FCC refused them compensation because they believed that it had a successor in title, or someone to whom ownership of company property had passed, who wasn't a British national. And Anisminic argued that the Foreign Compensation Commission had made a mistake of law by making its determination about Anisminic's claim for compensation. Anisminic maintained that the FCC had gone beyond its jurisdiction in making such a determination based upon whether a successor in title in fact existed. Now, this relied upon interpretation of the FCC's power to make determinations, which was set out in statute. And the relevant clause specified that the FCC must take 3 conditions into account, and only 3. Now, the Commission, by adding a 4th, whether Anisminic had a successor in title, and basing its decision on that, had made a determination that it had no power to make. And in the rationale, Lord Reid set out that the decision of the SEC was not protected by the ouster clause because there was no authority for the tribunal to construe its own powers in deciding what kind of determinations it could make. Only a superior court could decide the true extent of the powers of an inferior court. It wasn't the fact of the FCC making an error of law which was decisive, but that the kind of error it made led to it basing its decision on a matter that it had no right to deal with. That is, the issue about whether Anisminic had a successor in title who wasn't a British national. And the House of Lords held that the statute did not allow the FCC to make that a further requirement of giving compensation, and that the FCC had no authority to deem that it could. So the judgment, therefore, didn't attempt to rewrite the rules on ouster clauses or nullity, but it found that the specific kind of error the FCC made in its particular context did render its determination null, because the ouster clause did not give the FCC the power to alter or to reinterpret the terms on which its determinations must be based. And here, the court was exercising its powers in accordance with the purpose of judicial review, having regard to the statute, to Parliament's intent, and to its context. It's after Anisminic that the problems begin to arise, both because of conceptual leaps by the courts and by legal thinkers, and attempts by various governments, let's be frank, to make their own ouster clauses Anisminic proof. Now, Professor Feldman points to the opinions expressed obiter dicta by Lords Reid and Lord Pearce as the foundation of much of that confusion. Lord Reid explored the various scenarios in which a decision-maker might deprive themselves of jurisdiction, theorising that there may well be many kinds of error in these categories, from acting in bad faith to ignoring a mandatory requirement to take something into account. Lord Reid did not attempt to formulate a general rule about errors of law and jurisdiction, or to make comments on the limits of ouster clauses, but as Feldman argues, this passage has been taken to do exactly that. Now, that interpretation of Anisminic was confirmed in the case of O'Reilly and Macman, where the House of Lords found that any error must change the nature of the decision being made, making it outside the decision-maker's jurisdiction. And so those categories, the categorisation set out by Lord Reid, had in effect completely collapsed. Now, in response, Parliament attempted to overcome the now seemingly restricted boundaries of ouster clauses. For an ouster to be effective in this post-Anisminic world, review over every error had to be ousted, as any error could, or perhaps by necessity would, be a jurisdictional error and therefore a nullity. And so Parliament passed and attempted to pass extremely wide ouster clauses, wider than perhaps anyone would really consider necessary to achieve the policy intent. The Immigration Bill 2004 ouster is a very good example for an exhaustive ouster, as it went through every conceivable kind of error, whilst the Regulation of Investigatory Powers Act ouster for the Investigatory Powers Tribunal is an example of a more conceptual one, as it made provision for the body being able to decide its jurisdiction. Professor Eakins tells us that legislation is, in part, an act of communication by Parliament to the courts. The communication between them thus began to break down, because the principles surrounding ouster clauses and nullity and jurisdictional versus non-jurisdictional errors had distracted from what was really at stake. And it's this: what Parliament intended the jurisdiction of a certain body in particular circumstances to be. And that, remember, is how Anisminic actually was decided. Now, these issues came to a head in Privacy International, where the wide scope of the ouster I just mentioned fell foul of the judgment's determination of the requirements of the rule of law. In attempting to Anisminic proof the ouster clause, the legislation had strayed into even more contentious territory. The drafters attempted to evade the post-Anisminic argument that every error was a jurisdictional one by ousting review over the tribunal decisions about its own jurisdiction. Now, that fell down on 2 counts. First, that on a strict interpretation, the error made by the IPT was not about their jurisdiction in any case, so that the clause was redundant. Now, the court chose not to interpret the decisions about jurisdiction might be implicit in the determination of the IPT. That is, that they must have decided that they had jurisdiction to make the determination they were making. And second, that regardless of any wording, the court found that it should apply such a stringent type of interpretation of ouster clauses with a particular focus on the requirements of the rule of law that it would seem impossible for the ouster to work. But we must then ask ourselves, did Parliament pass a clause into legislation it intended not to have any effect? And hopefully, I think we can agree that such an interpretation would be quite a stretch. So we've reached a point where the growth of various concepts after Anisminic have meant Parliament enacting and proposing ouster clauses of seemingly extreme scope, and the courts then declining to judge clauses passed by Parliament to be of any effect at all. Complexity has led to confusion. But Privacy International also, I think, showed us a way out of this conceptual quandary. Lord Carnworth emphasised the artificiality of nullity and also did not preclude Parliament passing effective ouster clauses, so long as, in the words of the Cart judgment, those clauses are clear and explicit. And that's the challenge, I think, for legislators. Now, the dissenting judgments also point to different thinking on ouster clauses, looking at concepts such as a permitted field of activity, having more regard to statutory context and parliamentary intent, and the classes of error which the court should have supervision over from a rule of law perspective. And furthermore, all judgments accepted that there is a distinction between true jurisdictional errors, instances where the decision maker seriously breached their duties to act fairly, and all other errors. And these are the distinctions that the post-Anisminic case law, I think, had collapsed. And I believe that these distinctions hold the key to passing effective ousters that are respectful of the rule of law. So I hope the ouster that I am proposing points a way out of the marshes and onto firmer ground with the proper use and effectiveness of ouster clauses. The clause in the bill makes very clear what kind of decisions by the upper tribunal are not to be subject to review. And it also makes clear the kind of error which could be a ground of review. This, I believe, preserves the jurisdiction of the supervisory courts for specific reasons. Now, of course, for this to work, the courts would have to faithfully respect the distinctions drawn, and I'm confident that they will do that. It is very much my hope that this clause will banish the ghost of Anisminic, draw a line under it, and provide a proportionate, targeted, and just ouster clause. Thank you.
Thank you, Lord Chancellor. Thank you for an outstanding address. As I said, I'd like to remind people to raise their electronic hands. A few have already gone up. I can ask Robert Craig, University of Bristol Law School, distinguished contributor to pages of Judicial Power Project here at Policy Exchange. Robert, can you hear me?
Yes, I can hear you. Can you hear me?
Loud and clear, please.
Thank you. Robert Craig, University of Bristol. I speak in my personal capacity. Professor Eakin said today that this should be the beginning, but not the end of the reform process. What Oakeshottian and modest next steps does the Lord Chancellor anticipate making in future?
Well, thank you. I got the gist of that, and I'm grateful to you. And in the traditions of incrementalism, I think you can already see the contours of what the next steps might be. There's an ongoing review into the Human Rights Act of 1998, which is being conducted by Sir Peter Gross and a panel. That is working independently of government, as IRAL did. It will be reporting later this year, and it may well produce potential options which then the government could legislate upon. Remember that the manifesto commitment was to update the Human Rights Act. I've got that very much in mind, but I will be looking very carefully at the findings of the independent review before launching any potential consultation. And then there's another element to it all, which is the 2005 Constitutional Reform Act, which I've already started to discuss in prior speeches. I think that we can do better. I want to consult widely as to aspects of that particular act and how we can reform it and refine it, whether it's the very role of the Lord Chancellor themselves, the relationship with the judiciary, the question relating to the Supreme Court. All those issues, I think, are appropriate for mature reflection and consultation, and any change, I can assure everybody listening, will be in the best traditions of British incrementalism.
Thank you. Joshua Rosenberg, who requires no introduction from me in front of this audience. Joshua, can you hear me?
I can indeed, Dean. You can hear me, I take it.
Yes, loud and clear.
Good. Lord Chancellor, in your press release today, you said that the power to modify quashing orders is to be used at the discretion of individual judges. But your bill introduces a presumption. It says, in effect, that the court must suspend a quashing order or limit its retrospective effect, and I quote, unless it sees good reason not to do so. Surely that's fettering the judge's discretion.
Thank you, Joshua. I don't, with respect, agree. I think that any provision that absolutely retains that essential residual discretion of the court means that a discretion is present. I think the particular merit of the proposal that I put forward in the way that I have in the bill is to, in fact, go the other way and to allow parties who perhaps have been found to have crossed the line in the view of the courts and not acted in a lawful way, to give them the opportunity to rectify the situation, where previously it's been a bit of a Manichean choice, frankly, between quashing or issuing a declaratory order for the courts. And I think that many claimants might think that the position will be improved as a result of what we're doing. And as I say, that essential discretion remains. So far from it being a reduction in choice for the courts, I firmly believe that what I propose to do expands the options that they have.
Thank you. Lord Carlisle of Berriew, QC, former independent reviewer of terrorism legislation, amongst other things. Thank you for coming in. Can you hear me?
Yes, I can hear you. Can you hear me?
Loud and clear.
Thank you. Lord Chancellor, do you see the devolved parliaments within the United Kingdom as legitimate targets for incrementalism? And if so, how do you face the fact that none of the governments within those parliaments is the same as the national government?
Thank you, Alex. And I think both you and I have a particularly Welsh perspective on these things, but you're quite right to raise the wider United Kingdom dimension. And these particular proposals have been carefully couched to deal with England and Wales. And indeed, the terms of reference of the review very much reflected that. Of course, it's I would like to think that what we seek to do might be something that particularly the other separate jurisdictions would take up. But of course, respecting the fact that, for example, in Scotland, it's not a question of devolution, it always was a separate jurisdiction, even with the Act of Union, that they might not wish to do that. Having said that, I think these issues inevitably will bubble on. And whilst we're not here to talk about the issue of forum shopping, for example, I don't think anybody listening or contributing to these debates can ignore that particular issue. What I would say is that I think that in the best traditions of a leading common law jurisdiction like ours, I say we might be pointing a way forward that other people could adopt. But certainly as a Welsh Lord Chancellor of Great Britain, I'm extremely mindful of everything I do that might have an impact on the other jurisdictions, and I'll keep that position very carefully under review in the months ahead.
Thank you. Lord Howard of Lymm, QC. Can you hear us?
I can. I hope you can now hear me.
Loud and clear. Thank you.
Lord Chancellor, following on the first question you were asked, and indeed the earlier observations of Professor Eakins, you have placed great emphasis both in your speeches and indeed in your legislative response to some of the proposals that have been made for reform, notably by Policy Exchange's Judicial Power Project, on what you describe as the recent trend of judicial restraint. Those with minds more cynical than mine might suggest that that restraint might have been influenced by the fact that it was known that legislation was under consideration. What steps would you propose to take if that restraint proves to be short-lived?
Heard all of that.
I did.
Yep.
But Michael, thank you very much indeed, and it's great to hear from a fellow Llanelli lawyer. I think that I do trust the judiciary, you know. I really do. I believe in them. I have the particular privilege of having at one time, perhaps at a fairly low level, been a part-time member of it. And I know that the challenges that they face and the particular issues that sometimes confront them. And I've always been very frank about, you know, frankly, the failure of the legislature to get things right and to be as clear as possible, rather than giving, you know, ceding, if you like, the ground to the judiciary and giving them the problem of interpretation. I think that we owe a much higher degree of responsibility to get it right in the first place, to avoid these issues. Where I think we have legislation has a limit, however, is with regard to culture. And I do think that the issue about culture and approach is one that all of us can reflect upon. And I certainly, from my viewpoint, I see that happening now, and I see certainly a more, dare I say, a reflective approach, perhaps, from the judiciary about where we got to. I don't think any of us like to see a position where, in any way, the judiciary themselves are exposed in a, should we say, a personal or a political way to imputations that somehow their values or their political views, if they have any, come into play in the making of their decisions. And therefore, what I'm trying to do, and I make no apology for it, is to make the clear case that whilst government believes and trusts and has huge faith in our independent judiciary, it's also right for us as constitutional guardians to check the engine and to kick the tyres and to make sure that the vehicle is actually as roadworthy as it should be. And if that means some legislative incremental change, then so be it. But certainly, as far as I'm concerned, you know, with this particular role I have as this unusual bridge, if you like, between the worlds of the law and of politics, my job is made much easier if at both ends there is as much stability as possible. But both ends have that joint responsibility to get it right.
Thank you. Lord Panic, QC, can you hear me?
I can hear you. Can you hear me?
Loud and clear. Thank you.
Thank you very much. Lord Chancellor, I'm delighted that the bill proposes in the two clauses that address these questions so minimalist a reform of judicial review, especially after the extravagant proposals which were floated. I think the Judicial Power Project will be very disappointed by what you have wisely brought forward. I share your view that there's every reason to think that the judiciary will implement Clause 2 without any difficulty. And I would suggest to you that far more significant than the judicial review reforms is Chapter 2 of the bill that you published today, which reintroduces the online court procedure which lapsed during two general election campaigns, and I'm delighted to see those provisions being brought back. Thank you.
Well, thank you very much, David. Over the years, you and I have had polite disagreements, sometimes sharp disagreements. I'm sure there will be aspects of the bill that will be carefully scrutinised and criticised by those who have an interest and an important interest in these things. I did say throughout this process that I'm not here as a Marxist-Leninist revolutionary determined to smash everything up and to say that we started at year zero. I made no bones about the fact that I believe in incrementalism, and I think at all stages I've sought to say that in the main the system's working really well, and we are blessed and gifted with arms of the Constitution that are not just long established but are, I think, pretty well populated by men and women of quality and goodwill. The question is, can we do better? Can we tidy it up? This is my attempt to do that. But it doesn't come alone, of course, David. There will be other proposals coming down the line, which you might find, I don't know, more controversial. But I look forward to the discussions that no doubt you and I will have on this in the months ahead.
Thank you. Jonathan Jones, Linklaters. Can you hear me?
Yes, I can. Can I check if you can hear me?
Yes, loud and clear. Thank you.
Thank you very much. Lord Chancellor, I'm looking at the text of the bill on ouster clauses. And of course, the provision there is confined to particular decisions of the upper tribunal, which is itself a senior judicial tribunal. Can you say whether you see that provision as a template for ousting other types of decisions? For example, decisions of the executive itself?
Jonathan, I think that's a very fair question, and I have described this clause as not just important in terms of its own terms of reference and what it does in the context of cards, but what it might point the way to. Now, clearly, I think we've got to accept that either the one-size-fits-all ouster clause of 04, for example, or the cut out and paste approach will not work because, as you say, there are many different scenarios. And I think the key for us here is that we've got to be clear that if there is an ouster in one particular respect, there is another means by which that issue can be resolved. And I think in CART, it's very clear we've got an existing tribunal process that will allow applicants a very high degree, I would say, of procedural fairness and access to justice. And so I think that it's right of me to say that this indeed is a template or a prototype, if you like, but I think it would be wrong of me to then start to sketch out, precisely what scenario, a subsequent ouster clause might seek to fit. But what I can promise you, and from your many years' experience as Treasury Solicitor in the Government Legal Department, is that each time this is considered, it will be very carefully calibrated based upon the specific context. And it's that sense of context that I really think sometimes we lose in all of this debate. And that's why lawyers with experience of government like you and others on the call, I think, really get the political context argument in a way that sometimes is lost, frankly, in other forums. And that's why I welcome this discussion.
Thank you. Before asking you to summarise, Lord Chancellor, just one final question. If I exercise chair's privilege of the chair here and just your broad thoughts. I was interested in the formula you used that you said that judges had moved from looking at legality to proportionality. I was interested, there's almost been more recently, perhaps particularly, but not just in the socio-economic sphere, a move on to the desirability of laws. In other words, is this policy right or wrong, which is certainly a measure removed from the traditional conception of judicial role. I wonder your reflection on that third theme. Second, perhaps rather than widening it, as I've just done, limiting it and arising out of the dialogue which we've had at Policy Exchange, not always in agreement with figures such as Lord Carlisle, from your point of view, are some of the perhaps sharpest issues mostly in the national security realm, and in particular, the question also obviously talking to you as somebody with responsibility at your other hat, Department of Justice for prisons, is whether the balance has moved too much towards rights of the individual ahead of collective security of the law-abiding majority in that realm. I'm just interested in your thoughts on that. You know, how many of the problems are really national security? I think certainly successive Home Secretaries from the time of the last Labour government might also have an opinion on that, perhaps not so far removed in some ways from that of this government.
Well, Dean, there's a lot there in those two questions. I think the first one, in some ways, it might be slightly more straightforward to answer. I think my straightforward answer there is yes, there is a real danger that we end up in a position where judges are, in effect, being invited to step into a field where their values or the sort of moral judgment actually becomes more central than the analysis that we all expect them to deploy, bearing in mind their qualifications and experience. And that's something I worry about very, very much indeed. I don't want to see our judges exposed in that way. And I don't believe they want to be in that space either. I don't remotely believe it for one instant. It seems to me that it would offend against every fibre of certainly the thinking or the being of an English and Welsh and indeed a Scottish judge and a Northern Ireland judge. And that's why I think it's my job to try and police the field and to make sure that we don't either inadvertently or deliberately open the doors further there. I mean, a lot of that, of course, is tied up with the Human Rights Act. It's tempting for me to opine on that in more detail, but I've got to respect, and I should respect, Sir Peter's work on these matters, which is ongoing. But there's no doubt that in that area, in the HRA, there is a field in which the courts are invited to move into in a way that is not something, I think, that is consistent with the traditions that we are all used to in our jurisdictions. And I think that on your second question, well, of course, there's nothing new under the sun, and this particularly applies here to a greater or lesser extent. The balance between the collective interests of national security and frankly, the liberty or the freedoms of the individual is one that is always going to vex us and always going to throw up cases that will require expert judicial interpretation or involvement. Do I think that we're getting the balance right? I think in the main, yes. I think that having been involved, for example, in the Investigatory Powers Act, and I helped take that through the Commons when I was Solicitor General, I felt that we got to a very elegant balancing act between a decision being made by the executive that was then subject to a judicial lock when it comes to certain types of warrantry. And I think that system, since it is set up, has been working extremely well. We are lucky to have a tribunal of experienced judges now led by Sir Brian Leveson. And I think that relationship, if you like, a new type of comity, if you like, has really worked very well. Of course, we have the oversight of the Parliamentary Committee as well, the Security and Intelligence Committee, whose status was changed and enhanced by that particular piece of legislation. So a very good example there, I think, of the British way of striking that balance. And, I've mentioned that word comity. For me, people on the call probably have heard me say this many times, for me, that really is at the heart of all of this. And comity means more than just respect and acknowledgement. It actually means understanding. And one of the great things that frustrates me is that my role, the bridge, if you like, between the law and politics, has got, I think, more difficult over the past generation, because there are fewer people perhaps in the law who are in politics, and there is less of an understanding of the two worlds. We're becoming almost Disraelian in this concept of two nations being ignorant of each other, with some, of course, honourable exceptions, many of whom are on this call. But, that's something that we should all worry about. Whilst we don't want the worlds of law and politics to cosy up to each other, what we do want is a mutual understanding and a respect that is going to have to be built, I think, more with communication. And that's what I want to help foster in the years ahead.
Thank you, Lord Chancellor. Just if we want to make any further valedictory remarks today.
Dean, thank you again for giving me the opportunity to deliver my lecture here at Policy Exchange. A great pleasure for me, and my thanks to everybody on the call for their questions. And I'm looking forward to lively debate in both Houses of Parliament in the months ahead.
We look forward to welcome you all back here for some further lively debate as well, and play our own part in that. So on behalf of Policy Exchange's Judicial Power Project, thank you to you, Lord Chancellor, thank you to our questioners today, and we're delighted that this topic should be now vaulted to the top of the parliamentary agenda, where it rightly belongs, and we look forward to many more discussions in the years to come, as the Lord Chancellor himself has just foreshadowed. Thank you for your time. Over and out.